home or something. Yeah, I'm just like getting the link up now. Yes. Yeah.
Before leaving the next practice, before you use it. But I love my talk. Spencer, would you like to introduce yourself?
Introductions generally. Yes, introductions at the end. It's okay to give, I guess, a little preview, but in terms of names, whatever, I think we generally prefer that you do this at the end while you're giving general comments. But yes, I think in that case, yeah, I'm gonna say we're ready to start, and then we just wait for the signal from the tab room. Yes, okay, this room is now clear to start the trial.
Come to order. Call the case of Justice Carbo, the Shooting Star Gun Club LLC. Case number 23CD003. First, the court will hear oral argument on the plaintiff's pending motion. Counsel for Justice Carbo, please stand.
Yes, Your Honor. Alexander 10 for the plaintiff.
Yes, Your Honor. Paul Stevenson for the defense of Shooting Star.
All right, let's briefly. Party check 8 minutes. Possibility of up to an additional 2 minutes courtesy time by the discretion. The first 45 seconds, you may present your argument without interruption, and after that, the party jury is constructively active with this argument. So,
yes, Your Honor.
Right. So after the first 45 seconds, show your time card and let me know. I'll be able to see for my eyes. So you know we'll say stop at the appropriate time. Then courtesy time by may not, depending on how many questions I have, add to whatever the party's time.
Yes, Your Honor.
All right. Mr. Taylor, you may reserve up to 2 minutes of time.
Yes.
Argument. How much time would you like to give?
Your Honor, may I reserve 2 minutes for rebuttal?
2 minutes, right? I'll take care of that. And that means we'll have 6 minutes. All right. You may proceed. Yeah.
Permission to enter what?
Of course.
May it please the court, my name is Alexander Tan, and today I represent the plaintiff, Justice Carbo. Today the court ought to grant the plaintiff's motion in limine and deny the constitutional objections to the defense for 2 reasons. Firstly, given that the Second Amendment is not violated by the Responsible Firearms Sales Practices Act, also referred to as the Act, and secondly, given that the Act does comport with America's historical tradition regarding the regulation of firearms. Now, regarding the Second Amendment as a whole, it is defined as giving people the right to keep and bear arms. Now, in the case of District of Columbia versus Heller, this right was decided to be essential to the rights of ordinary law-abiding citizens. Now, this Second Amendment as a whole was decided to be a balancing act of maintaining the right to keep and bear arms for ordinary law-abiding citizens, while also maintaining the peace and the safety of public, with the understanding that firearms can have the potential for deadly cause. This act means not to restrict the actual right to keep and bear arms of individuals, but only to hold sellers liable and to ensure that the people receiving done through entrustment or sale are indeed safe and ordinary law-abiding citizens.
Are you making a facial challenge to the section?
No, Your Honor. The defense has brought up an as-applied challenge, which simply states that as applied, the application of this act to shooting star gun club is unconstitutional. However, in truth, it is not, given that the Second Amendment is the right to keep and bear arms, and the claim that we bring up against shooting star gun club is only that they are liable for the damages caused by Drew Cantrell, and that by entrusting a gun to Drew Cantrell, they violated the act. The standards that we use to analyze why Drew Cantrell does not fit under this act is that of presence of criminal record, potential presence of mental illness, a character or general trait of fair temperament, as well as age restriction and training in firearms. Now, under the case of Plum,
Who decides those criteria?
these criteria are decided by the seller, which is not unconstitutional. In the case of New York Rifle and Pistol Association versus Bruin, it was decided that as long as there are clear, objective values, such as the ones reflected in America's historical tradition of barring felons and those with mental illness from accessing firearms, as well as the 43 shall issue regimes, which restrict people from firearms if they do not meet certain criteria, it is constitutional. Now, if we look upon,
You believe that there's a tension between, basically between the limits burden on the seller, side, and individual.
yes, Your Honor.
Okay. And would you agree with me that if a seller of firearms, to say very mindful of this, that they are by definition going to be reducing their own revenue, their own profitability?
Yes, Your Honor. However, that does follow the understanding that to maintain the Second Amendment rights, there must be a balance between the maintenance of public safety as well as the maintenance of those that may keep and bear arms.
I don't disagree with you about that. Where are you getting that?
From the statements directly from the decision of the Supreme Court in the District of Columbia versus Heller, in which they analyzed the language of the Second Amendment and decided the scope of which the Second Amendment may be applied. In it, I also draw from the definition that these laws are directly in reference to ordinary law-abiding citizens. This act means not to restrict the rights of ordinary law-abiding citizens, nor does it mean to be open discretion. It only means to limit those that are not ordinary law-abiding citizens from accessing firearms and potentially causing harm. We do have a precedent for the restriction of potentially dangerous people for those that may not be under the definition of Heller ordinary law-abiding, with the 43 shall issue regimes, which have very clear objective values, as mentioned before. Now, it may be argued by opposing counsel, Mr. Stevenson, that there is the presence of necessity for a particular character trait of fair temperament or of safe practice. However, this is not unconstitutional to ask for. In the actual shall issue regime of Connecticut, which is still constitutional, they do use a fair temperament ask, and it is still considered objective under the Supreme Court's decision in the New York Rifle and Pistol Association versus Bruin.
But isn't that kind of subjective and vague?
While it may be subjective and vague on its facial value, this is based upon the totality of the circumstances as to whether this person has a history of crime, as to whether this person has a history of mental illness, or if this person does not have proper training in firearms. Now, another issue brought forth is the potential of why must this person have proper training in firearms or must have knowledge of firearms. In this case, we look to the decision made in Heller, in which Justice Kavanaugh himself said that it is not unconstitutional to ask for an individual to maintain that they have a proper understanding of the Second Amendment, as well as firearms itself, to maintain the safety and the good of the public. For all of these reasons stated above, the plaintiff asks that you grant our motion in limine and deny the constitutional objection of the defense, given that the Second Amendment is not violated by this act, but rather we are only meaning to ensure that those that have access to firearms are indeed safe, law-abiding citizens. Thank you.
Aren't you also alleging in your complaint that the defendant should be liable for selling your client a gun when the client was also unfit? Is that actually what you're arguing?
That is not the essential part of our claim, Your Honor. We are more focused upon the entrustment of a gun to Drew Cantrell. However, under these standards, if the seller, Shooting Star, did not properly consider the circumstances of Justice Carbo, they would be held liable for that as well. Now, we focus exactly on the entrustment of a gun to Drew Cantrell, given that that has caused damage, of which the act intends to prevent. This act would have prevented it by a thorough analysis of Drew Cantrell, seeing that he has no professional training in that of firearms, demonstrating that Shooting Star Gun Club did not take into consideration proper temperament or whether Drew Cantrell was a safe person as of nature. We look to the fact that Shooting Star Gun Club may not have considered the presence of a criminal record of Drew Cantrell.
Thank you, counsel.
Thank you, Your Honor.
Yes, Your Honor. I'd first like to ask Your Honor, like, copy of the statute.
Actually, that would be helpful. It's up here somewhere, but I haven't really been able to-
Permission to approach. Your Honor, my name is Paul Stevenson. Today I come before you with co-counsel for the plaintiff, the defendant, Shooting Star LLC. And today I ask that you oppose the plaintiff's motion in limine. Ask that you consequently deny the admission of the Empyrean 2007 statute for two reasons of ours. One being that it directly impedes upon the right to keep and bear arms per the Second Amendment as described to U.S. citizens. And second being that it has not shown that it follows any historical tradition throughout American history, as was ruled necessary in the New York Stolen Rifle Association, (NYRA). I will address those points accordingly, one at a time. First, beginning with that it directly impedes upon the right of a citizen to keep and bear arms. Now, opposing counsel, I would like to address first a misconstruction they made, in that this statute, they're only seeking to apply it to the